Okay, let's dive into a legal battle that all started with a single disputed meeting. You've got a homeowner on one side and his HOA on the other. Now, it might sound pretty straightforward, but trust me, this case is a masterclass in how the smallest details, and more importantly, your own actions, can have absolutely massive consequences. The whole thing really boils down to this one question. I mean, what happens when the fate of an entire meeting and every single decision made in it all comes down to whether or not a phone call actually happened? All right, let's set the scene. The date is November 28th, 2014. A homeowner named Attila Revesz files a petition against his HOA, the Shadow Mountain Villas Condominium Association, and his claim that their big annual meeting from earlier that year was basically a total sham. So the meeting he's targeting took place on May 22nd, 2014. Mr. Revesz's argument was really simple. He said the meeting was invalid because they didn't have a quorum. Now, a quorum is just a fancy word for the minimum number of people you need to make official decisions. He argued that without enough board members or homeowners there, the meeting broke the HOA's own rules, which would make everything that happened there totally null and void. So what kind of evidence did Mr. Revesz bring to the table? Let's break down his side of the story. Mr. Revesz's whole case was built on a few key points. He said there just weren't enough board members and not enough homeowners to make the meeting legit. And he had a star witness, Rick Sanchez, who was actually in the room. Sanchez testified he never saw a phone, never heard anyone talking on a call. From his point of view, there was no one else participating remotely, period. And then came what looked like the smoking gun. Mr. Revesz pulled out the draft minutes from the meeting. And if you look here on the left, it's spelled out in black and white. Board member Angelo Peri is marked absent. I mean, that's pretty powerful evidence that seems to back up his entire claim. But of course, there are always two sides to every story. So now let's flip it and hear the HOA's version of what went down on May 22nd. The HOA's manager, a woman named Joanne Greenstein, took the stand and painted a completely different picture. She testified, very confidently, that yep, 2 board members were physically there and the third, Angelo Peri, had joined by cell phone. So according to her, they absolutely had a quorum of board members, and they had enough homeowners present too. So what about those conflicting meeting minutes? Well, the HOA came prepared with their own version. As you can see now, the final adopted minutes tell a totally different story. They clearly state Angelo Peri was present by telephone. So now the judge is looking at 2 official-looking documents that say the exact opposite thing. So how can that even happen? How can 2 documents be so different? Well, the HOA's manager had a pretty simple answer. Drafts are, well, they're drafts. Their whole purpose is for people to review them and find errors, like, say, mistakenly marking someone absent, before they become the final official record. So imagine you're the judge. You've got a real dilemma on your hands. One witness says no phone call, another says yes, there was. One document says absent, the other says present. How in the world do you decide what actually happened? Well, it all comes down to this legal standard called preponderance of the evidence. Now, unlike a criminal case where you need proof beyond a reasonable doubt, in a civil case like this, you just have to show that your version of events is more likely true than not true. Think of it like the scales of justice. Mr. Revesz just had to tip those scales, even just a tiny bit, in his favor. In the end, the judge found the HOA manager's testimony to be more credible. And here's the really crucial distinction the judge made. Mr. Sanchez's testimony didn't prove a phone call didn't happen. It only proved that he wasn't aware of one. And, as the judge pointed out, not noticing something isn't the same thing as it not happening. So the evidence has been weighed, the decision is in. But the judge's final reasoning? It included an incredible twist that nobody saw coming. And you know what? It had nothing to do with that phone call at all. This quote, tucked away in a tiny footnote of the judge's decision, is where the petitioner's entire case just completely unravels. It points to the single most damaging piece of evidence against Mr. Revesz. And believe it or not, it was evidence that came from Mr. Revesz himself. Get this. At that exact same May 22nd meeting, the one Mr. Revesz was claiming was invalid, he himself was elected as a new member of the HOA's board of directors. And not only was he elected, but he accepted the position and actually went on to serve on the board. And that is the heart of it. right there. You can't really argue a meeting was illegitimate while at the same time accepting and benefiting from its results. By taking that board seat and acting as a director, Mr. Revesz's own actions essentially confirmed that the very meeting he was challenging was, in fact, valid. And with that, the judge's decision was simple and clear. Mr. Revesz had failed to prove his case, and even more importantly, his own behavior had completely undermined his argument. The petition was dismissed. The HOA won. The decision was handed down exactly 1 year later, on May 22, 2015. After a final review period passed without any challenges, the ruling became officially and legally binding on July 1st, and that closed the book on this case for good. You know, this case might seem like it's just about some squabble over an HOA meeting, but it leaves us all with a much bigger question to think about. In any dispute you find yourself in, what story are your own actions telling? Because, as we've just seen, sometimes those actions speak way louder than any argument you could ever hope to make.